Welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of You and the Law, a nonprofit whose mission is to provide legal information and resources to empower you in your legal affairs. While we provide legal information, it is in no way intended to be legal advice. If you have an issue, make sure that you retain the services of a licensed attorney. Today, we're continuing our Criminal Justice 101 series, and we're talking about the role of the courts in the criminal justice process. And to help us with that discussion, we have two of our great judges here in the state of Georgia. We have the Chief Magistrate Judge of the Magistrate Court of DeKalb County, Judge Beryl Anderson, and we have Superior Court Judge Tangela Berry. Judge Anderson is a graduate of Hampton University, where she received her Bachelor of Arts degree in Mass Media Arts and Journalism. She attended law school at the University of Akron. In 1995, she left private practice to become a staff attorney for the Honorable Denise Majette in the State Court of DeKalb County. In 1997, she joined the Atlanta Legal Aid Society, representing victims of domestic violence and citizens involved in landlord-tenant, consumer, education, family law, bankruptcy, and public benefits disputes. From 1999 to 2003, she served as a part-time associate magistrate judge in the Magistrate Court of DeKalb County while still working at the Atlanta Legal Aid. In 2003, Judge Anderson was selected to serve as the Deputy Chief of Staff to the United States Representative Denise Majette in the Georgia's 4th Congressional District. In 2005, she accepted a full-time appointment as an Associate Magistrate Judge in the Magistrate Court of DeKalb County. As well, in this capacity, she has handled criminal and civil matters in the Magistrate Court as well as in the State and Superior Courts of DeKalb County by designation. On May 27, 2010, she made history when she was appointed as the first African-American female to serve as the Chief Magistrate Judge in DeKalb County. In addition to serving on the magistrate bench, Judge Anderson has trained extensively on the issues of domestic violence and elder abuse. She's a member of the training faculty for the National Council of Family and Judicial Court Judges since 2007 and has served on the statewide faculty for the Institute of Continuing Judicial Education in Georgia since 2005. Welcome, Judge Anderson.
Thank you very much.
Judge Tangela Berry is a native of Thomasville, Georgia. She graduated from Albany State College and Stetson University College of Law. She began her legal career as a law clerk for a federal judge in Florida. After then, she relocated to Atlanta, where she continued her prosecution career with the DeKalb County District Attorney's Office. The DeKalb County District Attorney created the Domestic Violence Sexual Assault Unit. At that time, Judge Berry was selected as one of the 2 prosecutors assigned to this special unit, which was designed to protect the women of DeKalb County. In recognition of her efforts, she was awarded the Boundless Commitment to the Community Award in 2006. In 2007, she was named the Prosecuting Attorney of the Year by the DeKalb County District Attorney's Office. On December 2, 2008, Ms. Berry was elected as a DeKalb County Superior Court Judge. In this capacity, as Superior Court Judge, she handles felony cases ranging from petty theft to murder. Her civil caseload includes adoptions, divorces, and various other civil matters. In 2009, the Georgia Association of Black Women Attorneys awarded Judge Berry with the Bensetta Tipton Lane Award for her tireless dedication to family safety. She has continued her leadership roles by becoming a committee member of the Judicial Section of the Gate City Bar, and she's also a member of Delta Sigma Theta Sorority. Welcome, Judge Berry.
Thank you. Pleasure's mine.
As I told our audience, today we're going to be talking about the role of the courts in the criminal justice system. We've talked about what the prosecution does, what the police officers do, and limitations on both sides. We also talk about the defense attorney and their role in this process. So we now, somebody's been arrested, the accusation indictment has been brought, and now we're coming before the courts for the ultimate resolution for this case. So I want us to talk about, first of all, and I'll start with you, Chief Judge Anderson, what are the different levels of court in Georgia? I think, I run into people all the time that say the judge said it. And I think there's this perception that if you're a judge, you can do anything in any court whatsoever. So what are those levels of court?
Okay, there are various levels of court. We have courts that are called specialty courts. We have the juvenile court system. We have municipal court. Specifically in DeKalb County, that municipal court is called Recorder's Court. And that court deals specifically with traffic infractions and ordinance violations. We have magistrate court, where we provide a variety of function. I like to call it the court that is the gateway to the criminal justice system. In the event that someone is arrested, let me even back up. Law enforcement officers come to the magistrate court to obtain arrest and search warrants. After that individual is arrested on an arrest warrant, a magistrate judge is the first judge that you will see. The law requires you to go before a judge within 48 hours, and in some cases within 72 hours, to go before a judge, and that judge's duty, it would be a magistrate court judge's duty, often sitting by designation as a state or superior court judge, to tell you first and foremost what you're charged with, to inform you of your constitutional rights, to determine whether or not you wish to have an attorney appointed to represent you, tell you about a preliminary hearing, and schedule that hearing. And that's a lot of information, but when someone is arrested, you want to check with the sheriff's department and magistrate court right away to find out when that person is going to have what's called a first appearance hearing. And all of those things happen at that first appearance. Typically, bond is set at that first appearance hearing, except in those matters that are exclusively reserved for judges like Judge Berry. And that would be, by way of example, a murder. If you're charged with murder, you will still be brought before a magistrate court judge, but the judge cannot deal with the issue of bond. That would be reserved specifically for superior court judge like Judge Berry.
So it sounds like each level has different powers and different jurisdictions.
Absolutely.
As to what they can handle and what they can't handle.
Absolutely.
So you mentioned something about by designation.
Yes.
What does that mean?
The magistrate court was created back in 1983. It used to be the Justice of the Peace Court. It changed a bit in 1983, and magistrate court judges wear a lot of different hats. So in addition to dealing with criminal matters, we have the authority from state and superior court judges to sit for them, almost if you think about a substitute teacher, to perform certain functions and certain duties. And in any given day, as a magistrate court judge, you can wear 3 different hats. You can perform a function like preside over a small claims calendar. That's specifically a magistrate court function. I can also handle a state court misdemeanor matter, or a set bond in a case where someone's charged with a felony, and that is serving in the capacity of a superior court judge, but all by designation. And so it's a very lengthy. It's some paperwork that the judges of the various courts, state court and superior court, ask us to perform certain functions on their behalf.
Oh, so it's basically a duty of the state or superior court judge, but they're designating you to do it for them.
Absolutely. It makes the entire criminal justice system operate much more efficiently, because all of the judges at all levels, whether it's magistrate court, state court, or superior court level, are extremely busy, and it just operates like a well-greased machine. We are all interconnected, and I just don't think that any of us can operate without the other court.
Okay, well, Judge Berry, tell us about your level of court. We've heard about magistrate court, and we've heard about the municipal courts, what we know as the city courts. Mm-hmm. So what is actually is the jurisdiction or function of superior court?
Superior court has general jurisdiction. Essentially, we generally handle felony matters, we handle divorces, we handle adoptions. Divorces and adoptions, though Superior Court is the only place where you can handle those particular matters. Of course, we can designate them to other courts, but they will not have general jurisdiction of those matters. The same thing with regard to felonies. However, because we have general jurisdiction, we can still hear a misdemeanor case. We can still hear a DUI or a speeding, which would normally be handled in recorder's court or state court. And kind of to piggyback on your question and answer with regard to how the judicial system is set up, you have the municipal court, then you have magistrate court, then you have state court, then you have superior court. So superior court can handle many of those things at the bottom of that hierarchy.
A tier or hierarchy.
They can handle them, but it's not necessarily that we do handle them all.
But not vice versa.
But not vice versa, unless by designation. For example, if it was a misdemeanor, if you're in state court, a state court judge cannot handle a felony matter, unless, of course, the superior court designate a state court judge to handle it.
Okay.
And so it is, when you consider it like that, if it is a felony matter, that felony matter will only be handled in superior court. If it's a divorce or an adoption, they will only be handled in superior court. So there are certain things that must begin and in Superior Court.
Okay.
Depends
So it's
on
kind
what
of
it
the
is.
highest level trial court that we
It
have.
is the highest level trial court before you go to appeals.
Okay, so what are your individual roles? Okay, you have the parties in front of you. You have the small claims court where they're trying to decide a dispute amongst themselves, or you have the murder indictment, and you have the state and the prosecution there. What are your roles as the judge in those proceedings? I'll start with you, Judge Anderson.
Okay. I think that magistrate court is very unique in that it is commonly called the People's Court. It is a level of court where private individuals can come before the court to litigate a dispute without the need for an attorney. I like to say if you can afford an attorney, always get an attorney, but in the event that you cannot, you can come to magistrate court, and we'll use a small claims case, for example.
Like a Judge Mathis, Judge
Absolutely,
Judy type
but I'd like to
situation.
think that my judges handle things a lot more politely.
Without
and
the
a lot more
without the
efficiency.
entertainment feature.
And yes,
yeah.
and that's one of the things in our instructions is, it's not for entertainment value. These are real people with real disputes, and they're here because it's a last resort. Oftentimes people try to resolve their disputes without getting the courts involved, but when you do get the courts involved, it's going to be handled in a compassionate and efficient manner. But the parties have an opportunity to come in and dispose of that case. Magistrate court has exclusive jurisdiction to hear small claims cases where the amount claimed is $15,000 or less. So $15,000 plus a penny, you have to go to state court or
State
superior
court or
court.
superior court,
Right,
okay.
it bumps it up. However, if it's $15,000 or less, then you can handle that matter in magistrate court without the benefit of an attorney. The person that has been injured or seeking funds is called the plaintiff. The person that is defending that claim or the person who's being sued is a defendant. The judge's role is to make sure that in a form that is less structured, that parties are able to present their claims and their defenses and present evidence. The judge will listen to all of the evidence and make a decision. There are no jury trials held in magistrate court. So it is the judge who is the ultimate decision maker, and that is different than state and superior court levels. Remember, we talked about that hierarchy. So in magistrate court, the judge ultimately decides. But again, the rules of evidence don't really apply in magistrate court. It's a lot more relaxed, and it is a layman people's court. So you can come in and resolve that dispute. And we have small claims court. We have about 6 small claims court calendars a week. We try to make it convenient. One is at 2 p.m. and another's at 6 p.m. so that if you have to work, you can still come to the court. We try to make it very accessible and litigate that small claims dispute in DeKalb County Magistrate Court.
Okay. Now, Judge Barry, we hear that the juries come to your court.
That's correct.
So, what is your role in this whole process between the prosecution and defense?
With regard to the jury trials?
Yes.
Well, as Judge Anderson indicated, in Superior Court, we have trials. And we have trials based on whether or not, if it's a criminal matter, if the defendant is asking for a jury trial, then that means we're going to bring up 48 citizens of DeKalb County, and out of those 48, we are going to select 12 folks to become a part of the jury to be the ultimate decision maker, whether that person is guilty or not, or if it's a civil matter, whether that person is liable or not. And the court, basically, to some extent, is the referee between the plaintiff and the defendant, or the state of Georgia and the defendant, and we make sure that a jury, a fair and impartial jury, is selected to hear that matter.
Okay. So, before we go to break, because it's about time to do a break, I want to talk about the types of cases. If I have a certain case, what court would I be going to? And you just answered, kind of touched on small claims. Or are there any other type, and maybe protective orders, any other types of cases that you're hearing?
Yeah, so I want to say that that we fortunately hear all protective order cases by designation by Judge Barry, and the other judges on our bench have authorized us to do that. That is a matter that's exclusively for Superior Court judges, but we handle it by designation. So we hear all matters regarding temporary protective orders. We also hear a lot of landlord-tenant disputes, and as you know, with the foreclosure crisis that's going on, we hear an awful lot of landlord-tenant disputes and disputes not involving not equitable disputes, that would be before Judge Barry, but in those matters where someone is in a home or in an apartment and the landlord wants them removed, you come to court to deal with those issues, or with, I guess, matters.
It matters,
Okay,
yes,
and
ma'am.
other matters, and then we have small claims matters, as I said earlier, garnishments, other dispossessory actions when you have businesses that are asked to be removed from a certain property. Also, foreclosing on personal property, which would be like a vehicle repossession. Lots of collection cases. If someone defaults on a credit card or if someone defaults on a gym membership, those matters are resolved before magistrate court.
Well, I see why you say it was a gateway court.
Oh,
So
it's
it
the
takes you
gateway.
to everybody.
Exactly. Court.
Okay, now Judge Barry, we heard about the felonies.
Yes.
Is there anything else that would be heard? And you said adoptions.
Adoptions, divorces. We hear a lot of different types of civil matters. We hear from anything from a medical malpractice to a car accident. Those types of ranges in civil matters. We hear contract disputes. In criminal, like I said, even though we have exclusive jurisdiction over federal the felony matters, we hear misdemeanors as well as things as small as traffic tickets when they're connected with a felony or other misdemeanors.
But we
hear
did hear-
all issues of equity.
Okay, we did hear. Oh, finish your thought. Go ahead.
Oh, the issues dealing with equity, as Judge Anderson indicated. If you have a tenant and a landlord, that might start in magistrate court, but when you get to a point where someone's being foreclosed and the issue is, I didn't know who to pay, and so we want the courts to get involved, that might be more of an equitable issue, and that matter would come to Superior Court. So we hear a variety of things as well. But it does take more time to get into federal court, to get into
To Superior
Court. And so consequently, folks can, instead of filing an action in
Settle.
Superior Court, they can go to state court. State court moves a little faster
Okay.
with regard to those civil matters, but of course we can still hear it.
Okay, now in the criminal context, we heard a lot about things not collected properly, so motions to suppress and things of that nature. Is that a function of Superior Court as well?
Oh yes, definitely. In all felony cases, we have a motions calendar, and on that motions calendar, that's when you contest things such as search and seizure. You believe that you were stopped, the stop was illegal or improper. If you have an issue with regard to a confidential informant and you want to identify who that person was who called the authorities in the first place. All those types of issues we handle on a motions calendar prior to the trial calendar, so that some of those motion calendars are dispositive. For example, if they know that the matter was considered to be a lawful search, then that matter will proceed on to a trial. If the court decides that search was not a lawful search and all the evidence is going to be suppressed, then sometimes that matter will then be resolved without going to trial.
And see, and I think that's an important point, because a lot of people don't know how to stand up for their rights, and they end up having a greater situation. And for them to know that there's a court that can fix that.
Oh, yeah.
If it was done improperly. I think it's
Exactly.
very good information to put out there, because you're trying to stand up for your rights, but if you don't necessarily know how, you can end up with a whole other charge that will be legitimate because you're stepping outside those bounds. So
Yes.
that's an excellent point. We're going to take a break here.
Okay.
And when we come back, we're going to finish talking about the whole trial process, and we want to hear about how the courts can help in the community with different type of programs that they have. So we'll be back in just a second. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We're here talking to Chief Judge Beryl Anderson and Superior Court Judge Tangela Berry about the criminal justice system in our Criminal Justice 101 series. And before we left for the break, ladies, we talked about the whole levels of courts and the type of cases that you see and things of that nature. What I want to talk about now is, let's say that, something happened and I don't like the answer that you gave me, Judge Anderson, or that jury convicted me and I know I'm innocent. Is there a procedure even past you, Judge? We understand that you're kind of at the hierarchy on the trial court level. Is there a position past you where they can get redress, or a position past you and they get redress? But more importantly, what is that higher court looking at to determine if you actually have an issue of redress? And I guess I'll start with you, Judge Barry.
Okay. After any criminal trial, the court has to give you notice that you have the right to appeal. And you have the right to do that within 30 days. So, for example, during the course of their trial, if you believe that the court made an error with regard to the evidence that it allowed in, or with the selection of the jury, or any error that your attorney made an objection during the course of the trial, and you believe that the court did not entertain that objection properly, then you can appeal to the Court of Appeals, who would then take a look at the record. Everything is transcribed. Take a look at the record, look at the law, and make a decision as to whether or not the court made a proper decision regarding your matter.
So it's not a decision of whether you believe Junebug over Darrell.
No.
It's a matter of, was there a procedural issue?
It is a procedural issue with regard to, yes, because they do not go back and retry the case. They're not going to retry it again. They're not going to determine credibility issues and things of that nature that the court made an assessment on, unless, of course, it's a clear abuse. But for the most part, they're not going to retry the matter. They're only looking at the rulings that the court made. There's also another way in order to have your case addressed, and that's what we call a habeas. If you believe that there was a constitutional error,
constitutional error.
Yes, during the course of, from the beginning to the end, that affected your trial, and you want the courts to take a look at it, the appellate courts to take a look at it, then if it is a felony matter, you have 4 years to file that particular application. Mm-hmm. If it is a misdemeanor, then you would have 12 months to file that application. So those are two different recourses that you could potentially have if you're found guilty.
Okay, so all these levels of court, whether I go to the Court of Appeals, the Supreme Court of Georgia, the United States Supreme Court, they're looking for errors of process.
That's correct. They're looking for certain errors. If it is a appellate review, basically right after the trial is over, and you're asking the appeals court to say the court made an error in the course of that trial, then that is the 30-day mark that you have to file that application. Mm-hmm. If it is for a constitutional matter that happened during the course of your that happened during the course of the criminal process that affected that particular choice that you made at the trial level, then that's an habeas matter in which you would have 4 years in order to challenge it.
I think that's very important, because I think there's this perception that if I don't like what this one said, I'll just go to another one and present my same case, and maybe I'll get a different result. But that's not how the court system is set up. That's
correct. You can't shop around anyway.
Yeah.
The way the court is set up is not for you to judge shop. And essentially that's the reason why once you, for example, are found guilty in a case and then you're on probation and you violate probation, you come back before the same judge. Even if, for example, if you remain on probation for that particular term, any incidents that happen regarding that case will come back before the same judge. So there is no judge shopping. Your decision is, okay, well, that judge was, I didn't like that judge for some reason. I have a probation matter. I want to go before somebody else. That's not how it's happened. Now, for example, there could be some issues that a judge may recuse his or herself from a case, but it's not because the defendant wants to judge shop, what we call judge shopping.
Very important point on that, because I really think there is some miscommunication out there as to what can happen at these different levels of court.
Might I chime in?
No, absolutely.
Just to clear up some confusion. Back to magistrate court, it's a very unique animal. Magistrate court, again, the people's court, you can have in a civil proceeding, if you are not happy with that decision and you think the judge got it wrong, you have what's called, in legal terms, it's called a de novo review. But in layman's terms, it's called a do-over. So if you don't like the decision that that magistrate court judge made, then within 30 days, you can file an appeal and you can have that case reheard either in state court or before Judge Barry or some other judge in Superior Court.
So that's a special thing for magistrate court and the jurisdiction
Yes.
of the cases that you have.
Absolutely, and I think that creates some confusion if you think, boy, that judge got it wrong. If you're a magistrate court, you have every right to file for that de novo appeal and ask for a do-over.
And that's a very important distinction. Thank you for
Absolutely.
bringing that up. Now, I want to talk about in our last couple of minutes about different programs that we have in court, because it's not all about just the criminal trial and whether I'm going to prison or not, but I believe there are actual programs out there that actually help out with situations that you are encounter. I know most of them are at the magistrate level. So Judge Anderson, can you tell us some of the special courts that they have that impact the criminal justice system?
Okay, there are several specialty, I like to call them specialty calendars or specialty programs that we have in magistrate court, and it is working in conjunction with the district attorney's office and the solicitor general's office, whereby we have a variety of calendars where an individual who's charged with a criminal offense, whether it's a misdemeanor or a felony, if they are do not have an extensive criminal history and it is a nonviolent criminal offense, that individual can participate in a court-supervised diversion program whereby their case does not go through the usual criminal channels where they face a conviction, probation time, or a jail sentence. They are strictly monitored by a magistrate court judge on a monthly basis to make sure that, first and foremost, that they are not reoffending and that they comply with certain terms and conditions. We have the luxury of having a youthful offender calendar, a mental health diversion calendar, and a variety of different calendars where we take the time to look at the individual. Let's say a mental health court. We have the oldest mental health court in the state of Georgia. It's a very successful program whereby we make sure that individual takes their medication, make their regular doctor's visits. They come in for what's called a compliance calendar with a magistrate court judge, as I said, on a monthly basis to make sure that they stay on track. And in the event that they stay on track and finish whatever that course of treatment or that plan is for them, then those criminal charges are dismissed. And I'd like to say that that program would not be successful were it not for the confidence that the Superior Court judges and state court judges, district attorney, and solicitor general have in our court to allow us to monitor and create those programs.
So are they voluntary programs?
It's got to be it is voluntary, absolutely, but it has got to be the kind of case and a situation where we believe that at the end of that 1 year period, that individual will not reoffend and will have some treatment. We have some specialty courts.
Yeah, is there anything on the Superior Court level that that people
Yes.
should be aware of? Judge
Well,
Barry?
in judge court, in Superior Court, we have drug court, and drug court essentially means that in your matter that you came before the court involved drugs in some manner. It doesn't necessarily have to be that the actual charge involves drugs, but the reason why you did what the state is alleging you did was a result of drugs. For example, you burglarized the home, and you burglarized the home because you wanted to take the items to sell for drugs. There's an assessment done by the district attorney's office to make sure that you're a good fit for the program, and if you are, then you can go into the drug court program, and essentially if you complete that program, it will not show as a conviction on your criminal history. It's very similar to what we call the first offender program to some extent. First offender, if you haven't had any other felonies on your record and you decide to take the responsibility for that criminal action, then if you complete the probation term, whatever that might be, 2 or 3 years, and you're not involved in any other criminal activity, then that will in effect complete your first offender probation, and it will not show as a criminal conviction.
So you don't have a conviction if you go through the program.
You won't have a conviction if you go through the drug court program, or if you're first offender, or there's also a 1613-2, which is another program that's offered that would affect how that particular charge looks on your criminal history.
So it sounds like it's very important to try to get in some of these programs, because even though you may technically have done the deed, as they say, there are programs out there that can kind of get you the help that you need and also take care of the criminal side of it as well.
Exactly.
Very great information. Well, one thing I want to touch on before we leave, we hear a lot about discretion, especially on your side with sentencing.
Yes.
And a lot of people wonder, how can I have had a gun, it was armed robbery, but I only got $20. So how is it that I got 20 years in prison when I only got $20? Mm-hmm. And how does that factor, how does the discretion that the court has factor in that, and history and things of that nature, when the court is making a decision on what that sentence is going to be for somebody?
Well, there are certain things that the court doesn't have discretion on, and it's important for folks to know. There are armed robbery, felony or malice murder. There are various other things that we do not have discretion on. If you commit an armed robbery in the state of Georgia, you will be sentenced to at least 10 years.
And that's by statute?
That's by statute. If you commit a rape in the state of Georgia, you will be sentenced to 25 years. Or child molestation, you will be sentenced to 25 years in custody. And there is nothing that the judge can do about it, because it is by statute. You must serve that time, or you must be sentenced to that time. Now, there are certain things we have discretion on, for example, a theft. And even on certain thefts, depending on how many thefts that you've been charged with. If you've been charged with 3 thefts, you have to spend 1 year in custody. So it really depends on the type of case it is and what the statute says about the sentencing for that particular case. Certain things we have discretion on, but there's other things that we do not, depending on the circumstances of that particular person. Aggravated assault, for example, that's 1 through 20 years. The court does listen to the circumstances of that case, listens to the defendant's mitigating circumstances, listens to the criminal history, and then make a decision as to what that sentence should be. We also take the recommendation from the district attorneys who has worked with that case, and we take the recommendation as well from the defense attorney, and then we determine what is going to be the best way of sentencing for that particular case.
So just because I'm broke, because I'm a victim and I'm broke, doesn't mean you're gonna get a lighter sentence. Because whether you robbed me for $20 or whether you robbed me for $25,000,
yes, it
does not. That's not a factor in it.
I mean, I'm sure sometimes the amount of money might factor into how much probation you get, because one of the things that we're going to ask is that you pay that money back, restitution. And so if it's $25,000, you may be on probation longer because you need more time to pay that money back. So the money does factor. There's so many things that will factor into what the court decides to do. But the most important thing that we try to do, especially for me, is I'm trying to be fair. So I will consider all the factors that are brought before the court in order to make a fair and just decision. And so that means considering it all, including the law.
Well, that's a great way to end this case. And in this show. I want to thank you both ladies for all the information that you provided. I don't think you know just how much of a wealth of information that you've provided for our audience. Remember, Legally Speaking is shown every Sunday at 6 o'clock on www.youandthelawtoday.org. And remember, until next time, with every right comes responsibilities, so know your rights and accept your responsibilities. We'll see you next week.